I am especially proud to introduce our next speaker, my partner Joe Krasovec at Schiff Hardin. Before I tell you a little bit about him, I want to tell you that I have been at firm functions for 18 years with Joe, and I have never seen him in the outfit that Roger McCleary threw up on the screen. So it was a very clever photoshopping job that Roger did, but I promise you that's not the way Joe typically dresses. Joe's practice is focused on product liability and trial work. He is a 1989 graduate of Northwestern University School of Law and has tried cases to verdict in 15 states. He's also managed hundreds of other cases to successful resolution. Joe has participated in more than 30 mock trials and will speak to us today about that experience. Please welcome Joe Krasovec.
Okay, so 3 things about the photograph. Number 1, I apologize on behalf of myself and Roger McCleary for that being the first image that you were exposed to this morning. Number 2, clearly I'm a guy that's not afraid of color. Maybe I need to rethink that. And 3, the backstory of the photograph is at one of the last network events, my wife, we just were recently married last September, and that photograph came, and it is me. All efforts aside from Stacy, it is me. That photograph was taken while we were on our honeymoon in Bermuda. So I was wearing what is the appropriate attire in Bermuda, Bermuda shorts and Bermuda socks. Now, fast forward to this last meeting, and my wife and Roger McCleary, and this is a tribute really, or a testimonial to Roger's charm, and frankly his ability to extract information in discovery, because he started charming my wife, and pretty soon she's got her phone out, and she's showing him all these pictures from the honeymoon. And all of a sudden, oh, well, here, let me email you this photograph. And I'm thinking to myself, this cannot be good for me. This is going to end poorly, and now I see how it ends. So, Roger, I have sent a message to MK. We're having lunch today, and she's bringing your photo album. Okay, the business at hand. We've heard some great presentations about legal issues, and there are extraordinary trial lawyers in this room, extraordinary litigators, extraordinary problem solvers. I want you to take off your lawyer hat for a minute and put on the hat of a chief marketing officer, of a salesman. And I want you to think about how it is that you're going to determine how somebody's going to buy the product that you're selling. What's going to drive that person, your consumer, to make the decision to buy into what you're selling them? Big companies, let me get my, oh, here it is. Large corporations that have huge brands devote billions of dollars to this. Coca-Cola spends over $3 billion a year. Procter & Gamble spends over $150 million a year on something called focus groups. And in the marketing world, focus groups are 6 to 8 folks. They bring them together. They do them in different sections. And they expose those individuals to the product. They let them taste it. They let them feel it. And they expose them to the packaging and the marketing that goes with the product. And they determine who it is they're selling and what's driving their decision as to what they're going to purchase. I recently spoke with somebody who works in the advertising world, and when Pringles decided to roll out a new marketing campaign, they weren't changing the product, they weren't creating new flavors, they weren't doing anything to the potato chips. They were simply changing how they marketed the product. And they took over 24 months and 72 separate focus group sessions to define and then hone the marketing pitch that they were making. All right, so what in the world does this have to do with trial work? Well, when you step into a courtroom, you as a client, you as a company, as a defendant or a plaintiff, or you as the lawyer representing a party in the courtroom, when you walk into a courtroom and it's a jury trial, your case is like a product. Your jurors are your consumers. In a sense, you're a salesman, 8, 10, or 12 people at a time. And that's all that really matters. And again, there are amazing lawyers in this room, and we are very good at crafting legal arguments to set up our cases, to get the rulings that we want, to put the case in the right posture. But at the end of the day, what you want is a verdict in your favor. That's going to get you ultimately to a faster, better, and more efficient resolution of the case overall, if you're the one who winds up on the right side of the verdict. That means you've got to know how to sell your case. You've got to know how to package it. What's the order of proof that you're going to use? Who's your first witness? How are you going to present the jury your side of the case versus your opponent in the best light and in the light that will trigger the decisions that they're going to make when they go back and deliberate the decision in your favor? How important, and so the focus group for a lawyer is the mock trial. And that's what I'm going to talk to you a little bit about today. Now, let me tell you about the story about Rachel Barton and her $500,000 violin. And there are probably some of you in the audience that remember, if you lived in Chicago around 2000, 2001, 2002, there was a case involving a young girl who was a violinist. And she was a violin phenom. By age 11, she had played with the Chicago Symphony Orchestra. By age 18, she had played with most major symphony orchestras in the United States. She actually had produced a CD at that point. She was clearly a star on the rise. Her trajectory was going way up. She also taught violin to younger people up in a northern suburb of Chicago, the suburb of Winnetka. And one day, one cold January day in 1995, she boarded a commuter train. And she was going up to teach her class in Winnetka. She got on the train. With her, she had a big coat, because it's January in Chicago. She had a backpack, she had a lunch bag, and she had the violin that was actually belonged to a patron that had been given to her, in a violin case, in a soft case that had a shoulder strap on it. She boards the train goes up north. She's working on some paper, she's doing some paperwork, and suddenly she realizes that it's her stop. So she has to gather everything real quickly, puts her coat back on, slings the bags over her back and on her shoulder, including the violin case. She runs into the vestibule to go out the door. As she's trying to get out the door, the violin case hits a pole and catches a little bit. And so she's got to get the violin case around the pole. She does that, but now the doors are closing. She jumps off the train, and she turns to walk away, and the violin is behind the door. She's got the shoulder strap, and she starts yelling and screaming, don't stop, don't pull away, don't pull away. All the doors are shut, the conductors are on the train. Now, she had lost a violin. She actually lost her grandmother's violin when she was young. And this wasn't even her violin, this was a patron's violin. And she wasn't about to let it go. Yet that's all she would have had to do to save herself. The train starts to leave the station. She's screaming. Nobody hears her. Even bystanders start yelling. Nobody hears them. The train winds up dragging her almost 200 feet. Ultimately, one of her legs has to be amputated above the knee. Her foot actually was, we call it degloving, but the skin was torn off of her foot and she lost all of her toes. Now, she could still play the violin, but barely. Her career, as she knew it, was over. You had a horrific damages case. Her family went to a prominent Chicago law firm to bring a case. The case was filed in Cook County, Illinois. And the plaintiff's lawyers looked at this case and said, we have a wonderful damages case, but we've got some big problems. One, we're in a venue where our jurors are not necessarily going to identify with this young girl. She comes from a fairly privileged family, high socioeconomic status. Her violin is probably worth more than many of those jurors will make her 10 and 15 years. So they got to figure out how to get them to identify with her. Second, they've got a big comparative fault issue. In Illinois, if the plaintiff's comparative fault is greater than the defendant's, and there were several defendants in the case, but the primary defendant was the commuter rail line. If her fault was greater than the commuter rail line's fault, she takes nothing. It's a 0. So they got to figure out a way to get the jury to like Rachel Barton, because it's all about her, and to get the jury around the notion that really all she had to do was let go of the strap, and the violin would have fallen. She could have gone to the next stop and retrieved the violin. She could have saved herself. And that was going to be the primary argument of the commuter train. The lawyers in that case representing Miss Barton, they didn't mock try that case once. They didn't mock try it twice, not 3 times. They mock tried it 5 times. And as a result of all those iterations, all those mock trials, they came up with the theory of the near miss. The near miss was there were several people prior to Miss Barton's accident who had the same thing happen to them, except they, fortunately, didn't get injured. But it was the same problem in the conductors not properly checking to make sure that everybody's off the train, not having a proper procedure. And so the lawyers didn't start the case with Rachel. They didn't start the case with their experts. They didn't start the case with the defendant's witness or with an eyewitness. They started the case by calling witness after witness who had already experienced this same problem. They had all these near misses. This was the accident waiting to happen. So by the time the jury heard from Miss Barton, they were fully expecting. They knew what was going to happen. It desensitized them to Miss Barton's individual case. And what happened in the case? It was a $30+ million verdict in her favor. The comparative fault assigned to Rachel Barton, 4.5%. Verdict was upheld on appeal. Case ultimately settled. That's the power of mock trials. Now, I'm not necessarily saying you mock try your case 5 times, but I've actually spoken with the plaintiffs' lawyers who were involved in that case, and it was integral. They had no idea that that's how they needed to order their proof. Okay. So what are we talking about when we talk about a mock trial? And I bet that more than half of you have been involved in one or more mock trials in your careers. So I just want to make sure we're on the same page. We're just talking about you bring in a panel of 35 to 40 people. You bring them in your venue where you are. You do a 1-2 day truncated presentation of each side. That whole group of people is then divided into individual jury panels. It's all moderated by a jury consultant, and generally the cost is anywhere from $40,000 to $100,000. That's driven in large part by how much analysis you have the jury consultants do. I'm going to talk at the end about how $40,000 is plenty of money to get a good mock trial done that will give you the information that you need. All right, just a tiny bit here on the law with respect to mock trials, which as you might imagine, there isn't much. But just remember that your mock trials are protected by the attorney work product, as long as you're the one who's ordering it and conducting it. Your jury consultant is a non-testifying consulting expert, so he can't be called or he can't be required to divulge any information. The one practice tip you want to be aware of is there is a case out there, a case from Texas, where there was a testifying expert witness who actually took part in a mock jury trial. And ultimately, that expert was required to sit for a deposition and talk about his experience and what happened during the mock trial. Whether it would ever be relevant in trial and get to a jury is doubtful, but if you're going to do a mock trial, I suggest that you don't have anybody, either a testifying expert witness or a fact witness, present at least in the deliberations. You got to think about whether you want to have a fact witness live because you may want the jury to assess them, but don't have them sit through the deliberations so you'll avoid any potential disclosure issues. Picking the jury consultant. I think the most important thing about what consultant you pick is what experience have they had in the venue that you're going to be trying your case in, because you want the makeup of your jury, the demographics of your jury, to be as close as possible to your actual jury pool. So you want a good cross-section, a good makeup of what your veneer is going to look like that you're going to pick your jury from. Who attends? Key decision makers from the client, because they're obviously going to look at what happens during the mock trial. It's a little like seeing sausage made sometimes. It's very eye-opening. You want the lawyers on the team, and obviously you want the jury consultant, because you're going to have that jury consultant come back and help you pick the jury when you ultimately have your trial. The presentations, the key points here are get key documents and get key witnesses in front of this mock jury. Use videotape, deposition excerpts. If there's documents that are important, blow them up, put them on images that the jury can see. The other thing that's important is who plays the other side. I like to play my opponent. I like to get in the shoes of who I'm going to be against. It helps me understand their case, and it helps me understand how to defend their case. So I always flip sides and play the other side of the other side. The other option is to bring in an outsider. That gets expensive, and you have to get that person up to speed. So I always like to flip, and whoever the lead lawyer is on the case plays the other side. You don't videotape the presentations because you might find a guy in Bermuda shorts. Okay, issues to present. Test as many theories as possible, but don't have any clear winners. You want a lively debate. Be honest with your case. No garbage in, garbage out, but tweak the facts to make sure that you get the juries, the individual juries deliberating, that they're debating over the theories. Now, here's probably the most important part of this. Deliberations. Always videotape the jury deliberations. Again, you want a good mix of jurors on each side. You want to identify the high-impact jurors. What drives their decision-making on both sides? Because those are the people you're going to be looking for to get on your jury to be what I call your ambassadors inside the jury room. Your salesmen that are going to sell the other jurors to come over to your side. Don't take the damages numbers too seriously. Now, I'm going to try to go through this relatively quickly because I think I got to get through it. But what I want to show you is a clip from an actual mock trial. And just to give you a brief background to set this up, this is a case we tried in Texarkana about 2 years ago, Texarkana, Texas. It was a case involving a child car seat. The piece of the child car seat had broken. And that piece of the child car seat, the plaintiffs contend, was a structural element that helped keep the seat belts in place. This was the kind of child seat where you put the kid in, but the vehicle seat belts are what holds the kid in. It doesn't have its own harness. So you have a lap belt and a shoulder belt. The seat's a booster seat, so it boosts the child up so that they can fit properly in the lap and shoulder belt. The plaintiffs contend that this piece that broke off allowed the shoulder belt to slip down off of the child. And they pointed to two things. One, there was an eyewitness, you're going to hear about this, a guy named Bobby Jackson, who happened to be driving by this car right before the accident happened, who, on top of noticing the child's mother, who happened to be a very attractive woman in the front seat, also noticed that he was wearing his shoulder belt. Okay? That was a key piece of evidence that the plaintiffs were going to rely on in the case. The other piece of evidence was a relatively minor bruise on the child's forearm that they contended was made after the seatbelt migrated down off the shoulder, but held his arm in place and made a bruise there. He had a very large and very pronounced single seatbelt mark across his abdomen. See if there's anything else I need to tell you. Our theory of the case was that he actually had the belt behind his back, the shoulder belt behind his back. And what happened to the child in this accident, and nobody really disagreed about this, was his upper body flung so far forward very hard. And by the way, this was a 75-mile-an-hour collision. And it involved a Ford Explorer Sport Track. So Jennifer, vehicle performed outstandingly in this accident. Yeah, no issue at all there. So this child was flung so far forward so hard that he had what was called an atlanto-occipital injury. And so that meant that his C1 and C2 vertebrae stretched. And that resulted in complete quadriplegia of the child. Interestingly or miraculously, he had no brain injury. So this was a terribly sad case where you have a child who's perfectly cognitive, perfectly sound mind, in a body that needs a feeding tube, that needs a ventilator on which he's to breathe. The plaintiffs had a $30 million life care plan. They asked the jury to award almost $60 million. But the case really boiled down to, where was that shoulder belt? So you're going to see a clip from a mock trial that we conducted. There's about 9 people in the group. Just to set up the clip, everybody had gone around and given their take on the case. And at this point, there were 6 people who thought the seat was defective and that caused the child injuries. There were 4 who didn't. And we come to the last guy who's going to give his view on the case.
To the topic of discussing whether or not Jason, and let me just say right now that Jason is by far the greatest tragedy of all of this for me. I mean, I don't think any of us, our hearts are not just breaking for this child. But I go back to, this Bobby Jackson that was, eyeballing this woman driving down the road.
Yeah.
I mean, he wasn't, well, I got another term for it, but I'm not putting it in the report.
Be nice.
But at the end of the day, I don't know if I'm the only one that noticed this, but my 8th note underneath the plaintiff, when they brought out there, I put down witness demonstrated shoulder strap coming from opposite side. He showed us the way that strap come across that child like this, which in order for that strap to come across that child like that, from his left shoulder down to his right hip, would have put him on the driver's side of that vehicle.
That's right.
When we already know he's on the passenger side.
So he's not credible.
So either he's too busy eyeballing mama, or he's, I don't think he's got a dog in the hunt. I think he's just trying to be a good old boy, but get your facts straight. Yeah. I mean, if this is what you saw, I'm going to take you what you saw, which tells me that you saw this child on the other side, which we know he wasn't there. So therefore, we can't believe what you're saying.
Right.
I will say that when we go back to this, I mean, we can talk about mom all we want to, whether she's texting, whether she's talking, whether she hit her brakes, how fast she's going, and all the stuff there. But really, in my viewpoint, what they're asking us to decide is Graco responsible for the injuries to this child?
Yep.
Now, to me, the only way I can hold Graco 100% responsible and say, Graco, your product was defective and you're responsible for these injuries, if I see that child, Graco can, in my opinion, can only be responsible if and only if that product is used in the manner in which it was designed. And I'm not sure. First off, I think mama needs to understand who was the adult, who was the 5-year-old.
Yeah.
But, him deciding what kind of restraints. But at some point, an adult has to be an adult.
That's right.
And they have to take responsibility, and they have to turn around, and they have to, okay, Junior, make sure you keep that on. And if Junior don't want to keep it on, do what you need to do to make sure Junior's in compliance. At that. But, I took some other notes over here. I know somebody made the comment, I don't know who was in there, but when you hit your brakes and you start to go, those belts will lock in that vehicle.
Yes, it
If that belt is across that young man's not coming. If that young man comes forward and that belt's there, he's going to have a mark. It may be a slight mark, and I don't think it's going to be a slight mark. I think it's going to be a pretty distinguished mark. But I'm not a medical professional, but I do know myself. I carry something over my shoulder for any length of time. I wear overalls a lot, when I'm out working. When I get undressed, get ready to shower, I can show you where that overall was. And that's not a trauma.
Did you see the color of the one across his waist?
Exactly.
I mean, that tells you, to me,
That's where the load went.
That's where 100% of the load went. If he had that strap across here, it would have been, that mark, that was, oh my gosh.
So that juror, that gentleman, couldn't have said it any better than I could have. And when we structured our proof, we put in proof about the single abdomen mark. These are actual medical records. Again, one mark across the abdomen. And we put in as many of these records as we could. And we tailored the case to focus on that seatbelt mark. When the jury went to deliberate, the first thing that they asked for was an exemplar seat and belts. And I don't know what they did, but I'm pretty sure that they went back and they played with the belts and figured out that the only way that the child could be injured the way that he was if there was only one belt and it was across his abdomen, and that was the lap belt, and the shoulder belt wasn't there. So, to close, what you want out of the mock trial is you want the deliberations, you want the videotapes of those deliberations. I know Steve's going to talk to you about pretrial preparation. I agree that you don't do a mock trial a month or two before the trial. We did this one 5 months before trial. And I went back, though, during my preparation. I watched every one of these deliberations, and I crafted my voir dire to look for guys like him. So I had my jury consultant give me all the relevant information about each of the jurors so I could identify who I wanted, and gave me the sample voir dire. And then I crafted my proof to hit that point so that I could arm guys like him, and I don't know who it was, but it was somebody, guys like him to go into the jury room and make my case for me to the other jurors and get them to flip. In the end, jury came back in about an hour with a defense verdict. Thank you.